We are here in the case of Demetrius Davis Jr. versus Amelia Vogt, case number 24-00472NI. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on defendant's motion for summary disposition pursuant to MCR 2.116C10. So at this time, I would invite counsel to place your appearances on the record. We can begin with plaintiff.
Good morning, Your Honor. David Mateer appearing on behalf of the plaintiff, Demetrius Davis Jr.
Very good. Thank you, Mr. Mateer.
Good morning, Your Honor. Julian Heidenreich here on behalf of defendant Amelia Vogt.
Thank you, Mr. Heidenreich. Mr. Heidenreich, this is your motion, so I'll allow you to lead off. And I essentially read this as saying, Judge, here we have a violation of statute, which creates a scenario of negligence per se, and thus entitles you to summary disposition under the 51% comparative negligence rule. Is that right?
That is correct, Your Honor. There's some nuances there as well, and I'm sure you encountered those when you read the pleadings and everything else. There were a couple things that I would add, if it pleases the court.
Yeah, and I do have some questions as well. So
sure.
Why don't you go ahead and and I guess I'll lead off with my questions. And first of all, is you're relying on the Grand Rapids City Code that says users of bicycles on a sidewalk must slow down to a speed which will permit him or her to stop prior to entering the intersection and to yield the right of way to traffic on the intersecting street or roadway. Now, it appears to me from the attached deposition testimony and the police report and everyone's diagrams that this occurred at a entrance to a parking lot, not a intersection of two streets. Is your argument today that that requirement for him to slow and view the intersecting roadway also applies to all parking lot entrances and the like?
Well, Your Honor, it would be our position that it applies to any. So this is essentially where the parking lot intersects with Diamond. So yes, where Amelia Vogt was at the time of this accident, she was on a travel portion of the roadway. So to the extent that there was any contact with plaintiff's bicycle or the plaintiff, it would had to have been in this travel portion of the roadway designated for motor vehicles, as opposed to
You're referring to Diamond there, or the entryway to the parking lot?
It's the entryway to the parking lot, but it's the apron to the parking lot onto Diamond. So it's where Diamond and this parking lot intersect.
Sure. Yeah, no, and I'm unfortunately very familiar with the intersection because that's where the parking lot for Gordon Food Services, and my wife constantly sends me to go to Gordon Food Services to pick up items she has ordered from there. So I pull into that parking lot myself all the time on my way home from work. So I'm more familiar with this location than most. And yeah, and I guess the bottom line though is it's not a road, it's a parking lot entrance, right?
I would agree with that, Your Honor, but I would just reiterate that while it is a parking lot entrance, it is a traveled portion of the roadway designated for motor vehicles. So to the extent that...
And thus you would argue that the cyclist has a duty to slow at each potentially traveled portion of roadway to assess the situation to see if he has right of way.
That is correct, Your Honor.
Okay. All right. I think I understand that. And you know, the question occurred to me. I recall getting smacked on my bike when I was on the sidewalk when I was riding up in Traverse City to Immaculate Conception Middle School. So I must have been in about the 6th grade, riding my trusty 10-speed to school. And someone pulled out of, I think there was an alleyway that kind of went behind Immaculate. And as I was kind of pulling into school on the sidewalk, a car came out and the front of it hit me and knocked me down. I do remember that. Fortunately, I'd probably been hit by any number of my friends in football practice harder than that collision, and bounced right back up, none the worse for wear. The driver was very alarmed. She had killed me, I'm sure. And that particular alleyway was obstructed by the school. And, you know, it was a scenario where you had to pull out quite a ways to see the traffic. So I do remember being, you know, kind of in that scenario where I was struck by vehicle. And I never, just for the run, I don't know if Traverse has an ordinance like Grand Rapids, but I never had the slightest inclination. I was constantly, of course, watching out for cars as every cyclist does, but not that particular car at that particular time. So, different situation, same situation.
Well, I mean, I would suggest, Your Honor, without knowing more and without having taken your deposition,
I appreciate that.
in that instance, Your Honor, I would just assume that you were not, traveling at an excessive speed on your bicycle, though it was a 10 speed, through that.
It wasn't. I can't remember if I was late for school or not.
So Your Honor, I mean, I think that, that there's, as plaintiff's counsel has suggested, that there's no conviction of a violation of an ordinance. I don't think that's part of the analysis. That's something that I wanted to touch on. I did touch upon it in my reply brief, so I won't belabor it. But, to the extent that he was required to yield right of way to traffic on this particular part of the traveled roadway were designated for vehicles, the evidence would establish that he failed to do so. And in this dispositive motion setting, Your Honor, as you know, the court has to evaluate the evidence before it that's presented by the parties to the extent that it's substantively admissible under the court rules. And I've advanced my proofs showing that Ms. Vogt was looking where she was supposed to be looking. There's nothing to contradict that. Her testimony was that she was looking straight ahead and traveling, looking out in front of her, scanning the roadway, and that she was meaning to pull onto Diamond to make a right to head north on Diamond on her route to work. So there's no evidence at all to suggest that she wasn't paying attention. While it suggested that she may have been traveling at an unlawful or excessive rate of speed, there's actually no evidence of that. I mean, there's suggestion and speculation. I think plaintiff's counsel used the word extrapolation. What really he's inviting us to speculate that she was speeding. And what this all boils down to, Your Honor, is that in our system, in Michigan law, just because an accident happens does not in and of itself establish negligence. The Supreme Court has consistently held this, and the case is Huggins versus Scripter. That's the wrong case, Your Honor. The case that I'm referring to is a much older case than that, but it's one that's still good law. It's in my reply brief, and that's really all we have here. We have evidence of potentially an accident, and that's really it. I mean, plaintiff advances a few different theories. I think there's three that he argues should preclude granting my motion for summary disposition. The first one is what I just touched on, and that is that his client testified that she must have been traveling at an excessive rate of speed. He also testified that he never saw her. Stands to reason he doesn't have any way to, even speculate on her speed. He didn't see her. So he testified, he admitted this. So he can't really weigh in on that based upon his experience as an adult who has potentially driven a vehicle or at least observed vehicles on the roadway. He never saw the vehicle. He can't weigh in on the speed. And there's no expert testimony or opinion anywhere that would support the idea that Ms. Vogt was speeding when this happened. In fact, she testified that she was she was slowing and about to pull up onto Diamond. She wasn't going fast. There's no evidence to suggest that she actually was. The second point is what I also touched on earlier about there needing to be a conviction or suggesting there needs to be a conviction of this ordinance in order to show that there was a negligence per se issue here. That's not the case. It doesn't have to be a finding. It doesn't have to be a conviction. All that's required under Zenny versus Anderson is that it's punishable by some sort of a fine, which this particular code is. And that's really it. So he, to the extent that he admits he was on the sidewalk and traveled across the entrance to Diamond, which is designated for vehicles, I mean, he's basically admitting that he's subject to this code and that he would have had to yield right away to traffic. The other thing, which is very interesting, which I would call the third.
I want to just pause you for a second. Is there any, you mentioned the speed of the driver. Is there any evidence that, I mean, and we were talking about my bicycle accident, was I riding my bicycle at excessive speed? Now, I don't normally associate excessive speed with any bicycle, although certainly, we don't expect a Tour de France racer to be wailing down the sidewalk, at 50 miles an hour, not looking in any direction. Is there any suggestion the bike was going too fast?
Well, I would say yes, because he was unable to stop before a collision happened with the vehicle in the travel portion of the roadway. So that to me, because it doesn't, excessive speed. I mean, I'm not suggesting that the plaintiff was traveling like 25, 30 miles an hour on his bicycle. What I'm arguing is that he needed to be able to stop and couldn't. And that's why the accident happened, to the extent there actually was a collision. So yes, he was traveling at an excessive speed because he couldn't stop his bicycle in time to prevent himself from traveling into the path of this vehicle or into the side of the vehicle or however the collision occurred.
Because that's kind of indeterminate whether he struck the side of the vehicle or whether he was struck by the front of the vehicle.
Correct. I mean, I think that there's an issue as to what part of the vehicle, because when you look at the vehicle, Your Honor, and that's not in any of our briefs, at least it wasn't in mine.
No, I didn't see any reference, and both of them have a uniquely non-memory of the actual collision.
Yes, that is correct, Your Honor. And Ms. Vogt testified, though, that there was absolutely no damage to any part of her vehicle, which is very interesting. But all that's sort of a red herring, I think, Your Honor, because what it really boils down to is, to the extent there was a collision between the plaintiff on his bicycle and Ms. Vogt's vehicle, all we need to establish is that it happened in a part of the roadway designated for motor vehicles, and that the plaintiff failed to bring his vehicle to a stop or travel at a speed that would allow him to do so and stop short of this collision with the vehicle. So, it is odd that nobody can remember this happening, but at the same time, I think to the extent a collision occurred and where it occurred, that's what really matters here, is the location of the accident generally, as opposed to what part of the vehicle, was impacted. So, and the
Okay.
So the
Go
other,
ahead,
the
Mr.
other,
Arnold.
oh yeah, thank you, Your Honor. So, plaintiff's counsel, the third issue that he raises is that he's suggesting Miss Vogt was intoxicated when this accident happened. So, Miss Vogt candidly admitted that she occasionally uses marijuana to help her go to sleep at night. What she didn't say is that she absolutely did use marijuana that morning. She said she did not smoke marijuana that morning. She's also testified that she didn't even know for sure if she had used it the night before the accident happened. Even if she had, though, let's say she had, there is no evidence at all that her use of the marijuana the night before resulted in her being intoxicated much, much later, in an entirely new day, when this accident happened. There would have to be a toxicologist or a neuropharmacologist to come in and say, here's, based upon her consumption in this quantity of marijuana at this time, with her having eaten this amount of food and sleeping this amount of hours, there'd have to be a lot of foundation for that in order for there to be an actual fact established that she was intoxicated. This is really no different than somebody taking prescription Ambien the night before, or Xanax, or having a couple drinks the night before. The police didn't even show up to this accident, Your Honor. There was no toxicology screen of Ms. Vogt. There is no actual evidence that she was even intoxicated from marijuana or anything else the night before this accident. All we can do is speculate that she may have been under the influence of marijuana at the time this accident happened. At best, that's what we can do. And at best, that's not allowed under the court rules and under the Michigan law, requiring that the plaintiff, because I've shifted the burden, I've established my case for summary disposition, arguing that there's negligence per se, and all the other things that I've outlined in my motion, based upon my actual evidence, which is testimony, documentary evidence. And at that point, the burden is shifted to plaintiff to show a question of fact with substantively admissible evidence. We have nothing but speculation as to potential excessive speed as to Ms. Vogt. We have nothing but speculation as to the idea she may have been intoxicated from consumption of marijuana at some point before this accident happened. What we don't have is an established fact as to either of those things. So that's really it. Those are plaintiff's arguments. And so we have nothing but speculation here, Your Honor, that they've been able to proffer to say that a question of fact exists, which does not satisfy the court rules or Michigan law. But what I'm also arguing, Your Honor, is that we don't even have any evidence that Ms. Vogt was actually negligent. The only thing that they could possibly cite to is the fact of the accident, which the Supreme Court has held is not sufficient. Where is the evidence, Your Honor, that Ms. Vogt was negligent? There was an accident with a bicyclist in the part of the road designated for motor vehicles. That's not enough. The Supreme Court has said that's not enough. What the Supreme Court has also said, Your Honor, is that that motor vehiclists, drivers and bicyclists or pedestrians, they have duties that are reciprocal. So it's not, the rights and duties of motor vehicle drivers and pedestrians are reciprocal. So the pedestrians have to exercise reasonable care and caution when they're traveling in the roadway, like the plaintiff was here. They can't just haphazardly drive their bicycle or haphazardly walk out into the roadway wherever they want, because they are not governing themselves reasonably under the law if they do that. And drivers, it stands to reason, and the court has held this throughout the years on these types of issues, that motorists are entitled to assume that people on the roadway, whether it's pedestrians, bicyclists, other motor vehicle drivers, are following the rules of the road and acting reasonably. They're entitled to assume this. And drivers don't have to guard against every single thing that could happen on the roadway at any given time. That's not what the law requires. So not only is there there's negligence per se as to plaintiff, and a rebuttable presumption of negligence as to plaintiff and comparative fault as to plaintiff, there's also a complete absence of any admissible evidence that Ms. Vogt was negligent in causing this accident. Because there can be all these different causes of an accident. There can be multiple proximate causes for any given accident, but the law requires that in order for something to be the cause and fact and the proximate cause, there has to be substantial evidence that one is the proximate cause as opposed to another. And here, what I'm arguing is, we not only do we not have any evidence at all that Ms. Vogt was negligent, we actually have evidence that the plaintiff was negligent and negligent per se. And there's no evidence that the plaintiff has presented to the court in response to my motion to suggest that a question of fact exists or to rebut that presumption of negligence per se. And so if the court has any questions, I'm happy to address them. But let
me hear what Mr. Mateer has to say. And then if I have any others, or if you wish to have a moment after he speaks, I'll grant it. So Mr. Mateer, response.
Thank you, Your Honor. So what we have here is a he said versus she said. An alleged violation of the Grand Rapids City Ordinance is no different than my alleged violations of these motor vehicle codes. Assuming that Mr. Davis violated a Grand Rapids ordinance is evidence of some negligence. It's not evidence of 100% negligence. It's not evidence of 1% negligence. It's still a question of fact for the jury. I would love if all I ever had to do was allege a violation of the motor vehicle code, because then the only trials I would ever be a part of would be solely about damages. All I have to do is allege a violation of a motor vehicle code, and that's per se negligence, 100%. We're done. That's the end of the analysis. That's not how this is. This is a he said, she said scenario.
And I think legally what you're saying then, Mr. Mateer, is that even if I find that he was negligent per se, he was riding his bike and didn't take the proper precautions approaching this roadway, Judge, you don't have to find that establishes 51%. and dismiss the case.
Correct, Your Honor.
Okay,
Correct. And I have more that I'd like to add if it pleases the court.
please.
So, and this court has to view evidence in the light most favorable to my client. I want to correct a couple things that were misstated on the record. Miss Vogt did unequivocally admit to consuming marijuana the night before. That's in my brief. That's cut and pasted into my brief. More of a red herring than anything. I mean, the main thrust of my argument is, as you just accurately summated, Your Honor, this is a he said, she said. It's a question of fact for a jury as to what percentage of fault we're going to give to the plaintiff, if any.
Yeah, and I mean, as I see the negligence straight up case, taking away the marijuana. Well, in the speed, I also, I don't think there's there's not an allegation here that she just blew through this intersection without stopping. My read of the deposition testimony is that she stopped and at worst failed to observe the bicycle and pulled out and struck the bicycle as it was crossing in front of her. Not that, I didn't see anyone saying this car came out of nowhere at 40 miles an hour pulling out of the parking lot. And, it didn't look like she was late for work or, on some sort of emergency mission. It was a pretty routine day. And, if any negligence is to be ascribed to her, it's failure to observe the cycle on the sidewalk.
Right, Your Honor. I mean, nobody's testified conclusively as to speed for either party, admittedly. My client did testify that she came out of nowhere. He didn't see her. I mean, what we heard from Mr. Heidenreich essentially today is his closing argument for a jury.
All right. Well, let me bounce back to Mr. Heidenreich.
Well, so, Your Honor, I would agree with Mr. Mateer that there's some he said, she said going on, but here's the problem with his argument is that one side of that has evidence to back it up and the other side does not. My side has evidence to back up its position, which she said. His side, with he said, has nothing other than speculation to back up those positions. There's no question that Miss Vogt or any motorist on the roadway has the duty to drive reasonably, to keep their vehicle under control, to scan the area, things like that. What I'm saying, Your Honor, is there's no evidence that Mr. Mateer has proffered to show that Miss Vogt, my client, failed to do those things. Her testimony was that she was doing all of those things, and there is nothing before you in evidence to suggest otherwise, which means procedurally, the plaintiff has failed to present evidence to the extent it's substantively admissible to show there's a question of fact. And all that they're really arguing by saying she didn't see the bicyclist, whatever, that's really just saying an accident happened, therefore negligence. And that's not the way the law works. So I think while you can call my closing argument, I imagine that if it were my closing argument, I'd bring up much more detail about the injuries and the recovery and things like that. But no, this is a dispositive motion setting. My side has evidence to support its position and the other side does not. So summary disposition is proper under those circumstances.
And you're saying the fact that it's undisputed that this was a bike on a sidewalk. I mean, no one's saying this bike like darted into the road from between parked cars, for example, or something like that. It doesn't create, I should treat that cyclist more or less like a vehicle that failed to yield the right of way.
That is absolutely correct, because it was not on the sidewalk when this accident happened. It was on the travel portion of the roadway designated for motor vehicles.
Yes, right. And it was crossing this this entryway to the parking lot. I mean, right. It had come from the sidewalk, but it had entered some sort of motor vehicle space at that point, and arguably under the statute had the duty to yield. So, okay, well, I have heard the arguments in the briefs today, and though I do appreciate the argument that the statutory violation here, and I think it's certainly arguable that there was a statutory violation. The cyclist here does have the obligation to, while riding on a sidewalk, maintain a lookout for intersections such as this, and also if he sees a vehicle legally within the intersection, obviously the bicycle can't just of his own volition go and ram himself into the side of the vehicle in a kamikaze-like manner, and then on top of it, add insult to injury, sue the vehicle under the No Fault Act for negligent operation of the vehicle. That would never work. However, there are nuances of this case and some unknowns here, importantly, that take it out of that range, and that is unquestionably prior to the collision, the plaintiff was operating his bicycle on a sidewalk where there would be an expectation of potentially pedestrian traffic, bicycle traffic. Now, bicycles can go too fast on the sidewalk, but inherently there we're going into a question of fact, and there wasn't any particular testimony by either of these individuals that they're riding particularly fast. He said he was riding down the sidewalk. My recollection is that he was going to go to the bike rack at the Cap and Keg or the party cooler there on the corner of Michigan and Diamond. I have never been inside the party cooler, though, because of my aforementioned runs to Gordon Food Service, I'm aware that it's there. And that in effect, he never saw the defendant coming. Defendant, on the other hand, and defendant's testimony is pretty consistent with that. She said she pulls up to that intersection of the parking lot and Diamond Avenue, where she intends to make a right turn. Presumably, obviously, she would check to see if there were any oncoming vehicles from the south, from Michigan Street direction, on Diamond, because she wouldn't want to pull in front of another vehicle. And then as she's pulling into the roadway that is Diamond from the parking lot, and that is an area where one would expect vehicles to travel, and certainly arguably an area where one should yield under the cyclist statute, strikes or is struck by, and it's very unclear from the testimony what happened there. And I agree with Mr. Heidenreich, that's another fact question here by two folks that have a less than clear memory of the actual collision. However, I do agree with plaintiff on the idea that even if I consider this in light most favorable to the plaintiff, even if he violated the statute, that does not necessarily make him 51% or more negligent in this case. In that, obviously, cyclists, pedestrians, moms pushing strollers, etc., the sort of things, kids riding tricycles that one might see on the sidewalk, are in a unique position of vulnerability to motor vehicles. And motor vehicles, as everyone knows, have a duty to keep a lookout where there's an intersection with a sidewalk or a crosswalk on a street, which this is essentially like, even though there's no marked crosswalk here. There is a sidewalk roadway intersection where one would expect pedestrian traffic from or pedestrian, bicycle, tricycle, stroller traffic, jogger traffic to intersect. That one would have to be on the lookout for those things. And further, obviously, as has been proved many times in many cases, it's harder to see bikes, pedestrians, joggers, motorcycles than it is to see a full-blown car with headlights, etc. And thus, both parties would have duties approaching this intersection of a parking lot and Diamond Avenue to be on the lookout and to take reasonable steps to avoid colliding with each other. And it's not for the court to make the determination, even if there was this violation of the statute, that the cyclist per se was more than 50% at fault. There would be an argument if he had been convicted that perhaps the matter was res judicata and that the fault would be established, past 50%. But I think by what I've heard from Mr. Mateer today, he would argue that that probably isn't the case, that even in the case of a violation like that, there is this duty that's incumbent upon the other motorist here, the defendant, to look out for anticipated non-motorized traffic on the sidewalk. And of course, as a motorist myself, and also as a pedestrian, occasional bicycle rider and jogger and stroller pusher and things like that, the importance of both parties looking out, seems abundantly clear to me. And that is, of course, no one gets, as it were, a free pass here. And I would push back on Mr. Heiderreich's assertion that there's no evidence that the driver here was negligent. Well, arguably, the bicyclist was in a place where he could have been seen, and she didn't see him, failed to see that he was coming. It wasn't because she didn't look in that direction. Well, obviously those are all arguments to be made and placed before a jury, who can then ascribe the level of fault. Certainly, Mr. Heidenreich can argue all of the above, that the cyclist had the duty to be on the lookout and to slow down and to yield to vehicles as well. However, I don't think that even if I take the fact, that violation to be the case here, because there was a collision, and the bicyclist, just as clearly as the driver said, I didn't see the cyclist. The cyclist said, I didn't see the driver. So, however, I do need to take these in the light most favorable to the plaintiff, and I think there is a scenario where a plaintiff could prove that the driver bore 51% and they bore 49% of the fault in this case, thus making it inappropriate for summary disposition by the court at this stage of proceedings. So I'll deny the motion at this time. Mr. Mateer, will you send me a order?
Yes, Your Honor, I will do that.
Much appreciated. Anything else we should place on the record at this time, gents?
Your Honor, can I submit that order to you with a stipulation from counsel, or would you like that a 7-day order?
Either way is fine with me.
All right. Thank you.
Very good.
Nothing for me, Your Honor.
Thanks, gents. Well briefed and well argued today.
Thank you.
Thanks, Your Honor. Appreciate it.